It acts as a charter of a company because it deals with both internal and external factor. We call it as a charter of company. When it comes in terms of a public company, okay, so that the company name end with limited. When it comes in terms of a private company, the name of the company should end from private limited. In case of winding up of the company, there are two kind of things that we must notice: compulsory winding up, voluntary winding up. Hello everyone, a warm welcome to one and all. I am Mr. Hemant Kumar from the Department of Commerce and Management, Vidhyaashram First Grade College, MYSURU, the Temple of Excellence. In today's session, we are going with session 2 of Unit 2. It's about formation of a company. This is agenda of today's session. We are going with a Memorandum of Association, that is MOA, followed by Articles of Association, that is AOA, and also steps to alter MOA and AOA. Okay, so these are the topics that we need to cover in today's session. And in the same way, in the previous session, as we had explained about important documents that is required for the incorporation of the company. Okay, so the first one is Memorandum of Association, second one is Articles of the Association, followed by Prospectus. Of course, this prospectus is not mandatory for each and every company. It is mandatory only for public company, not for private company, because a private group of people are going to form a company in the business perspective. Fine. So here, when it comes in terms of three important documents, as I said, prospectus, Memorandum of Association, and Articles of Association. This prospectus is also known as invitation to the stakeholders or investors. Okay. So prospectus, we call it as a invitation of the company. Followed by Memorandum of the Association is also known as a charter of the company, because all the kinds of rules, regulations will be listed in Memorandum of Association. Followed by Articles of Association is also known as a rule book of a company. Okay, so all the kinds of the regulation which is relevant for the internal environment will be listed in the articles. When it comes in terms of Memorandum of the Association, it is the only thing which is going to build the gap between external and internal environment. It is going to describe all the internal and the external factors, that is Memorandum of Association. So going to the Memorandum of Association, it is one of the important topic in the exam point of view. Also, dear students, please do consider this concept very carefully. The Memorandum of Association is a fundamental legal document that defines a company's structure, objective, and powers. So it is all about the structure of the company, objectives of the company, and also the powers in the hands of the company. It acts as a charter of a company because it deals with both internal and external factor. We call it as a charter of company, and is necessary for incorporation under Companies Act 2013. Okay, so before a company follow Companies Act 2013, the company were following Companies Act 1956. Okay, so which lead for take birth of a Companies Act 2013. Okay, so if we need to register under Companies Act 2013, we must have this kind of a document, that is Memorandum of Association. The Memorandum of Association serve as a guide for both the company and outsiders like investors. Okay, so it is going to serve for both the people. As I said, we call it as a charter of the company. Okay, because it is going to serve both inside and outsiders, that is inside the company and outside the company, internal environment and external environments. Okay, investors, bankers, and government authorities. Okay, that is Memorandum of Association. It clearly states that the company can legally do. Without it, company cannot legally come into existence, because it plays a vital role when it comes in terms of Memorandum of Association. Okay, so without this Memorandum of Association, the company cannot come out legally, it cannot get incorporated. Okay, it is one of a important document, that is Memorandum of Association. Okay, so it is also known as charter of the company. Please don't forget this. Okay, key components of Memorandum of Association. When it comes in terms of Memorandum of Association, we need to consider few key components which is included in MOA. That is, firstly, the name clause. Name clause is going to define about a name of the company. Whether it is a public company, the name must end with a limited. That is Okay, if it is public company, let me say it is the company name is XYZ. Okay, so if it is a public company, the name must end with limited, that is XYZ Limited. Is it a public company? If it is a private limited, okay, so XYZ Private Limited. Okay, so it is going to describe a full name of the company, first thing. Second thing is, so this name should not be copied with the existence company. Okay, so for example, right now some other company had kept XYZ name. Okay, this is the name of a company, so some other company had kept the same name. I'm not supposed to copy the same thing. Okay, and in the same way, while when it comes in terms of name of the company, I should not take, or I should not affect the sovereignty of our nation. I should not copy the logo of our nation, that is triple lion logo, or I should not copy the Ashoka Chakra, or I should not take the symbol as a national flag. Okay, so these are all the things I should not go with this. Okay, so that we call it as a name clause. Here in the name clause, I am going to highlight, okay, the what exactly the name of my company. Okay, followed by registered office clause. Registered office clause is nothing but the registered office legal address. Okay, so where exactly the office of this company is located. Okay, so where the company is located, that we call it as a registered office clause. Okay, in which district, in which state, in which nation it is located. Okay, so what is the contact number of the registered office. Okay, all the things will be mentioned in the registered office clause. Objective clause. When it comes in terms of objective clause, it is going to define about the core objective of the organization. What exactly my organization is going to do. Best example is Tata Group of Companies. Okay, say for example, Tata Consultancy Service. What is the core objective of Tata Consultancy Service? Consultancy service. The name itself it is going to define. Okay, so consultancy service. It is purely IT based service sector. It is. Okay, say for example, a Tata Motors. Okay, so it is a automobile manufacturing industry. Okay, so it is going to say about the objective of the business. Objective clause. Liability clause. When it comes in terms of a liability clause, it is going to define about a liability of a shareholders, whether it is a limited liability or unlimited liability. Okay, so there is a company called Unlimited Company. Okay, so that there is a unlimited liability. Okay, in the hands of a shareholder. For example, I'm a shareholder for Unlimited Company. Okay, say what happens? So if the company undergo any kind of a loss, any kind of uncertainties, okay, I am supposed to sell my complete property, my personal property, and recover the debts of the company. Okay, that is unlimited company. Okay, so when it comes in terms of a limited company, whether it is a private company or the public company or any other company, okay, so there is a protection for the liability of a shareholder. Okay, so it is limited liability company. Okay, so that we call it as a liability. So it is going to define about the liability of the shareholder in a company. Capital clause. So capital clause is going to say about a capital of the company. So what exactly the capital of the company, what is the total investment for the company. Okay, so what is the bank loan that is being taken for the company, what is a public offering that is being given, so as a shares, as a debenture, as a bonds, so what is how they are going to classify the funds. And in the lastly, subscription clause. Subscription is clause is always how they are going to offer the shares and debentures to the general public. Okay, so here how they had arranged the capital, how much bank loan that they had bought, what is the initial investment of the people, so what is the total number of investment that they had offered to the public that they had given. So it has been classified into subscription clause. So what is the total capital subscribed, okay, so by the general public. Okay, so I am going to offer shares to the public, I'm going to offer debentures to the public. Okay, so this shares, debentures and bonds will be issued to the public only by public company, not by the private company. Okay, so the shares is not distributed to the general public when it comes in terms of a private company. Followed by articles of association. When it comes in terms of articles of association, it is also known as a rule book of a company, which is going to list all the kinds of rules or regulations or flexibilities which is going to happen inside the organization. But when it comes in terms of a memorandum of association, it is going to build the gap between internal and external environment. Here articles of the association only internal environment, not affect the external environment. When it comes in terms of articles of association, the articles of association is a internal rule book of a company. So they are going to define it as a internal rule book of a company, which is going to make rules and regulations inside the organization, not outside the organization, that governs how it operates and it's managed. Okay, how exactly it is going to operate inside the organization and how it get managed. It provide detailed rules and procedures for day-to-day functioning of the company, all the kinds of rules or regulations or restrictions. Okay, so all the things will be listed in the articles of association. The AOA is subordinate to memorandum of association, meaning it cannot override the objectives or powers defined in memorandum of association. Okay, articles of the association should follow memorandum of association. Okay, so it do not have any kind of a right to override the memorandum of association. The articles of the association, okay, do not have any right to go against memorandum of association. It is primarily meant for insiders such as directors, officers and shareholders to ensure proper management. Okay, so to ensure the proper management, the functionality of the company, to maintain the transparency in the company of the company. Okay, so a well-defined AOA helps maintain smooth operations and avoid internal conflict. Okay, so if articles of the association is transparent, rules and regulations are clear and cut, all the people strictly follow all the kinds of rules and regulations, there will be no conflict inside the organization. Okay, so that is all about articles of association. When it comes in terms of the components of articles of association, firstly, management structure. Okay, so management structure, it is going to say about how exactly the management structure is. Okay, so how exactly they had distributed the management. Meetings and decision making. Okay, so whatever the meetings that get conducted in the organization, what is the protocol for the conduction of the meeting, what is the formality, who must attend the meeting, which are all the meetings that is being conducted, all the details will be given, followed by decision making. Okay, so what exactly the conclusion of the meeting. For example, if I want to select a managing director of my organization, I need to go with the directors board meeting. Okay, so after that, what is the conclusion, what is the findings that I get from conduction of meeting, what is the ultimate decision that I'm going to take, okay, by conduction of meeting, followed by share transfer and allotment. Okay, so here it is going to say about the transferability of shares, whether my company shares can be easily transferred or not transferred. When it comes in terms of a public company, the shares can easily get transferred from one person to another person, but not in public company. In public company, we cannot transfer shares easily. There are certain restrictions that is been put by the company or the organization when it comes in terms of private company, because it is a small group of people, a private group of people had started the organization. Okay, there are certain restrictions. For example, okay, so shareholder in a private company, okay, so I'll be holding around 30% of shares of the company. So can I transfer completely 30% share to some other person? No, I can transfer up to 50%, not more than 50%. This is just example. Okay, so that we call it as a share transfer and allotment, how they are going to allot the shares, and in the same way is going to define about the transferability of shares. Okay, followed by dividend distribution. Dividend distribution, what is a dividend policy that is being adopted by the organization? Okay, what is the percentage of dividend that is being given to the shareholders, equity shareholders and preference shareholders? Okay, so these are all the things that is been mentioned and given in terms of articles of association. Dispute resolution, any kind of a dispute that is going to happen, how to sort out the problem. Okay, who is going to sort the problem? Okay, so how they are going to consider the dispute, how they are going to consider the uncertainties. Okay, so that they are going to mention over here. And winding up of the company, in case of winding up of the company, there are two kind of things that we must notice: compulsory winding up, voluntary winding up. When it comes in terms of compulsory winding up of the company, so if there is any order from the law, we must wind the company, we must wind the company. What is the actual protocol? So while winding up the company, what exactly I am supposed to do? Okay, so when it comes in terms of a voluntary winding up of the company, okay, so So what exactly the protocol I am supposed to follow, which are all the reasons that I can say for wind up of the company or the liquidation of the company. Okay, so these are all the things that we need to consider when it comes in terms of articles of the association. What I mean to say is, starting from the management structure, who are all the people who are present, who is a managing director, who are the chairman, who are the directors of the company, all the details are will given, and also they are going to describe about the rights, duties and responsibilities of a particular managerial personnel that we are going to study further in unit 3. Okay, so that the management structure is going to say. Okay, so starting from management structure till the winding up of the company, all the things are included in the articles of association. Moving forward, steps to alter memorandum of association and articles of association. So here the question is there any provision under Companies Act 2013 for the alteration of memorandum of association or articles of association? Of course, yes. So we can change articles of association, anything in articles of association, but not in memorandum of association. We can change only few things, not everything. But in articles of association, we can change everything according to Companies Act 2013. Okay, say what happens. So we do have a 7-step when it comes in terms of changes in memorandum of association and articles of association. Let me say I want to change my dividend policy. So before this year, I had given 5% of dividend. This year, I want to declare 10% of dividend to my shareholders. So what exactly the protocol is? Okay, so because I must change when it comes in terms of articles of association, I should change the dividend policy, right? Okay, so how I am going to change the dividend policy, what exactly the protocol is. Okay, so firstly, as soon as I decide to issue 10% of dividend for the shareholders, I am going to conduct a board meeting of directors. Okay, so board meeting I need to conduct. Okay, in that meeting, the agenda must be, can I declare 10% dividend to my shareholders? That is the agenda of the day. And finally, all the directors had given the permission, had agreed to give 10% of dividend to the shareholders. Okay, so that is a decision that is made in board of directors meeting, followed by, okay, so if board of directors agree for this thing, that is not enough. It should get agreed by shareholders also. So to take the opinion by the shareholders, there is a legal formality. We must conduct a meeting. To conduct a meeting, what we must do? We must send a notice of general meeting. So by conducting a general meeting, by discussing a topic about increment or increase in the dividend policy, okay, changes in the dividend policy, that is 5% to 10%, we need to send a notice. So clear described notice I need to send. So explanatory statement. So what is explanatory statement? To grab the attention of the shareholder, okay, to have a huge investment to my organization, I need to declare 10%. Okay, and also to retain a shareholder for a longer period of time, I need to declare 10% of dividend to the shareholders. Okay, so that is a explanatory statement. Explanatory statement is going to explain what exactly the problem is. The problem is only 5% of dividend is being declared by the organization, but the shareholders are not satisfied with 5% of dividend. I need to increase the dividend to retain the shareholders and also to attract more number of shareholders to invest on my company. Okay, so what I did, okay, so I am going to give the explanatory statement. I am going to explain the reason is shareholders are not satisfied with the dividend policy of my organization. So I want to change my dividend policy from 5% to 10% because my company had made huge profit in the previous year. Okay, so again, so with this notice of general meeting, I had given the explanatory statement to the shareholder, followed by general meeting. Okay, after inviting the people, okay, so that I am going to conduct a general meeting of shareholders and directors of the company. Okay, both the people should present in this meeting, and here also they are going to discuss about agenda of a day. It's about change in dividend policy, whether I can go with a 10% dividend policy. What if I won't go with 10% dividend? What will be the effect? Okay, so these are all the things will be discussed, and finally it is going to declare. Okay, so it is going to decide that, okay, so I can declare 10% of dividend to the shareholders, and after that filing with a register of companies. They are going to file the same, that is regarding the changes in the dividend policy of the organization. Okay, so in ROC, that is register of the company. Okay, so whatever the changes, that is memorandum or articles of the association, that is going to happen in the organization should registered with ROC. If it is not registered with ROC, it is not valid. Then next one, registers approval. Okay, so until and unless, okay, so the approval has been given by ROC, we cannot consider it. Okay, we cannot declare it. Okay, finally the approval is been given by ROC, and also I am supposed to update in company records. All the kinds of the financial records I need to mention, in the prospectus I need to mention, and in the same way in all the aspects, in all the conditions I need to mention and keep the same kind of document in official website as well. Okay, that we call it as a updating company records. It is one of the important topic in the exam point of view, dear students. Please do note this topic. Okay, I just brief the same. Okay, so alteration of memorandum of association or articles of association, we can change everything in articles of association but not in memorandum of association, because it deals with both internal and external factors. This articles of association, we call it as a rule book of my organization, which deals with only internal environment. It is known as charter of the organization. Okay, that is memorandum of association, followed by board meeting. So if one decision should be taken, should be discussed with the board meeting with the directors. Notice of general meeting. So I need to go with the notice of general meeting to call the shareholders to take the opinion from the shareholders. Again, with explanatory statement, I need to explain what exactly the problem is, so how to sort out the problem, so causes and cons I need to mention over there in the explanatory statement. Finally, the annual general meeting or general meeting will be conducted. Okay, so after conduction of general meeting, finally there is a conclusion, there is a decision should be taken, so whether I can take or no. So if I can take, I must filing with register of the company. The same decision should be filed under the register of the company regarding the increment in terms of the dividend policy. And also there is a approval from the register of the company. After getting the approval, I can update in the company records, including the official website of the company. This is the actual protocol if there is any kind of a changes that is needed in memorandum or articles of the association under Companies Act 2013. In next session, we are going with certificate of commencement of business. It is one of the important document that is required for formation of the company. Okay, without this document, a company cannot run or come to existence. And formation of a global company. Here we are going to know about what exactly the global company is and how to form a global company. What is exact protocol for the formation of a global company, followed by features of a global company. Okay, features of a global company, followed by steps involved in formation of a global company. Which are all the steps that we need to take for the formation of a global company. Thank you.